Chapter 15: Access and Parenting Time. Introduction. When parents live apart, respectful relationships between parents and healthy relationships between parent and child are vitally important for both child well-being and stable child support payments. The Child Support Program has played a critical role in supporting such relationships. This chapter discusses parenting time agreements and custody orders as they relate to the establishment of a child support obligation and the role that child support agencies can play in helping to facilitate parenting time agreements. It explains the history of the state access and visitation program, including allowable services and regulatory standards. The chapter also reviews domestic violence safeguards that are important for a child support attorney and a tribunal to follow when establishing parenting time in cases that involve a risk of harm. Enacted by Part B of the Social Security Amendments of 1974, Title IV-D of the Social Security Act created the Program for Child Support Enforcement and Establishment of Paternity, referred to as the IV-D Program. Basic core services in this unique federal-state partnership were locating absent parents, establishing paternity, and enforcing and modifying child support orders. The primary role in the early years was welfare reimbursement for aid to families with dependent children (AFDITs). In the majority of states, child support and visitation and/or parenting time are legally separated. For parents, however, they are emotionally and financially connected. As early as 1979, research indicated that fathers with little or no contact with their children paid only 34% of their child support obligation, while fathers with regular contact paid 85% of their obligation. Subsequent studies revealed that 2/3 of parents with frequent contact with their children paid child support, while only 1/3 of those with no contact made payments. With the expectation that access to both parents was extremely beneficial to children and would foster regular payment of child support, the Federal Office of Child Support Enforcement (OCS) in 1990 launched child access demonstration projects in 7 states to test the impact of mediation, parent education, and counseling relating to increased involvement of fathers in their children's lives. A 1995 evaluation of these demonstration projects confirmed that access and visitation was a complex problem for many separated and divorced parents, and recommended that courts and agencies develop no and low-cost dispute resolution interventions, such as mediation. Program legislation. Access and visitation grants to states. Subsequently, Congress enacted legislation authorizing grants for access and visitation programs (AV programs). The goal of the grants was to enable states to establish and administer programs to support and facilitate non-custodial parents' access to and visitation with their children. The Personal Responsibility and Work Opportunity Reconciliation Act of 1996 (PR-WORA) authorized formula grants to the states and territories totaling $10 million per year. Allowable services include mediation, development of parenting plans, counseling, parent education, visitation enforcement, supervised visitation and neutral drop-off, and development of guidelines for visitation and alternative custody arrangements. The legislation requires the Administration for Children and Families (ACF) to provide a state a minimum grant of $100,000 and requires a state match minimum of 10% of the federal grant support. A state can fulfill the match by cash or in-kind contributions. Specific program services used to promote statutory purposes are left to the discretion of states. Examples of program services currently being implemented by states and territories include legal services helplines and websites, limited legal services for drafting parenting plans and settling parenting disputes, dispute resolution mediation, parenting education including legal education, interactive, online parenting plan order development platforms, development of parenting plans, visitation enforcement including monitoring, supervision, and neutral drop-off and pickup, the development of guidelines for visitation and alternative custody arrangements. A state may directly provide services or contract with courts, local public agencies, or nonprofit private entities to provide the services. The state must monitor, ensure adequate family violence safeguards are in place, and report on its grant program. Program services do not have to be statewide or limited to parents participating in the child support program, but an increasing number of states are prioritizing services for families with child support cases and using remote service delivery to expand the reach of program services. The state Roman 4D agency administers the grant funds in a majority of states. OCS administers this program on behalf of AICF. Regulatory standards are set forth in 45 CFR. Part 303. Since 1997, the AIV programs have served more than 16 million parents, including custodial parents, non-custodial parents, and a small, yet growing, number of grandparents and legal guardians. The total number of families served each year from federal fiscal year FFY20 FFY 2018 has dramatically increased from less than 48,000 in FFY 2000 to more than 80,000 in FFY 2018. Each state has contact information for its access and visitation program on the OCS website. Sense of Congress. In 2014, Congress enacted the following as part of the Preventing Sex Trafficking and Strengthening Families Act. Sense of the Congress. It is the sense of the Congress that one establishing parenting time arrangements when obtaining child support orders is an important goal which should be accompanied by strong family violence safeguards, and two states should use existing funding sources to support the establishment of parenting time arrangements, including child support incentives, access and visitation grants, and healthy marriage promotion and responsible fatherhood grants. Early research on participant outcomes. OCS commissioned a study in 20,012,002 of participant outcomes of state AV programs in 9 states, involving 970 cases. The study made the following findings. State AV programs serve a diverse group of parents, particularly those at lower socioeconomic levels. Supervised visitation programs serve the most disadvantaged parents and those at greatest risk. 2/3 to almost 3/4 of parents reported reaching agreements in mediation on custody, visitation, and child support issues. Between 36% and 39% of non-custodial parents reported increases in child contact following service delivery. Participants in state AV programs increased their child support payments, with never-married parents showing the most dramatic increases in compliance. 90% of parents who participated in supervised visitation characterized this service as a safe place to conduct visits. In 2006, OCS commissioned a second study to examine the impact of the AVE programs on increasing non-custodial parents' access to and visitation with their children. This study involved 3 major program types: mediation, parent education, and supervised visitation. It consisted of telephone interviews with program participants and a review of their child support records, both before and after program participation. The study found that among the non-custodial parents who were paying less than 100% of what was owed during the 12 months prior to project participation, 64% of participants in the mediation programs increased payments following program participation. 93% of participants in parent education programs increased payments, and 53% in supervised visitation programs increased payments. The report noted that court mediation programs had done little to address the access and visitation problems of never-married parents. This is an important population to serve since the birth rate for unmarried women is high. The report concluded that AV programs should focus on serving never-married parents for significant increases in child support payments. The report also concluded that AV programs should be prepared to offer resources to parents with domestic violence histories. Profile of custodial mothers and fathers. According to Census Bureau data about custodial parents in 2017, the majority of custodial parents were mothers. The distribution of custodial parents by marital status differed between mothers and fathers. About 42% of custodial mothers were currently divorced or separated, and 44% had never been married. The remaining mothers consisted of 16.3% who were currently married and 13% who were widowed. About 55% of custodial fathers were divorced or separated, and 29.3% had never married. A majority, approximately 86% of the 5.4 million custodial parents due child support payments in 2017 had arrangements for joint child custody or visitation privileges with the non-custodial parent. Custodial parents with shared parenting time arrangements who were due support received more child support than those due child support without such arrangements. In situations where there was court-ordered physical or legal joint custody of children, approximately 58% of custodial parents due support in 2017 received the full amount compared to only 31.7% of custodial parents with children who had no contact with their other parent. It is important for law and policymakers to be aware of such Census Bureau data as they explore how to best address the relationship between child support and parenting time. Parenting time orders. Laws governing custody and visitation and/or parenting time are state-specific. Usually, the best interest of the child is the paramount factor. States tend to use three approaches to address parenting time. One approach is a standard visitation schedule. Standard visitation plans are similar to child support guidelines. They presume that a standard parenting time schedule will work for the majority of families, with options to deviate based on specific family characteristics. Some standard plans include an umbrella statement that parents may follow their own schedule if both parties agree, and that it's only when the parties don't agree that they must follow the schedule in the standard plan. The schedule typically delineates what time will be spent with each parent, including weekends, holidays, and vacations. Although standard schedules are a low-cost way to address parenting time, in many cases, courts and parties need to ensure they address domestic violence concerns. Another approach is to use neutral or third-party assistance. Mediators or facilitators can help parents create a customized parenting plan. Although potentially more expensive, mediated or facilitated agreements often result in higher parent satisfaction and a better understanding of the parenting plan terms. A third approach is the self-help approach. Parents access resources such as a parenting plan they download from the internet. They then can customize it based on their needs. Parents using publicly available forms must usually still file a petition with the court and pay a filing fee in order for it to be enforceable. Divorcing parents in family court usually can establish custody, visitation, and parenting time orders during the divorce process. Unmarried parents do not have a similar forum. Child support and other family law systems are often distinct, requiring unmarried parents to participate in multiple, often overlapping, legal proceedings to resolve issues of child support and parenting time. Addressing both the calculation of child support and the amount of parenting time as part of the same process increases efficiency and reduces the burdens on parents of being involved in multiple administrative or judicial processes. However, historically, the Child Support Agency in most states has provided no assistance in developing parenting time orders. In large part, this lack of assistance is because current law does not allow states to use Title IV funds to pay for parenting time services. There are several states, however, with child support program initiatives that incorporate parenting time orders into initial child support orders. Such programs find support in research showing that non-custodial fathers who pay child support are more likely to stay involved in their children's lives, and programs designed to improve parental contact with non-custodial children are associated with improved child support outcomes. Many of the initiatives focus on memorializing parenting arrangements where the parents have already agreed upon the division of time. Domestic violence safeguards are an important part of these programs. Often, the Child Support Agency is working in partnership with courts and other agencies. Examples of these state programs include Florida. Florida legislation authorizes the Florida Department of Revenue, the Title IV agency, to establish parenting time plans agreed to by both parents in Title IV child support actions. The legislation provides a standard IV parenting plan that the parents can adopt. The plan includes timetables that specify the time, including overnights and holidays, a child may spend with each parent. The parents can also agree to a different parenting plan, which can be incorporated into the support order. Michigan. The state assists in establishing parenting time orders concurrently with initial child support orders through its Friend of the Court FOC program and mediation services. With the help of the FOC, parents can also file motions and schedule hearings to address parenting time concerns. Texas. The state has established the most standardized, statewide program incorporating parenting time orders. Pursuant to state law, parenting time arrangements are established in the initial child support order, so parents receiving a child support order also receive a parenting time order known as a possession order. Texas also provides parents assistance in shared parenting, including a nationally recognized hotline in which attorneys provide free legal information regarding parenting time and child support. California, Orange County. The statewide Family Law Facilitator Program offers free legal assistance to self-represented litigants in family court. In Orange County, that office may assist parents with developing parenting time agreements. While the attorneys do not provide direct legal representation, information is provided on parenting time and child support with legal referrals as appropriate. Minnesota, Hennepin County. The county operates a co-parent court that establishes paternity, support, and parenting time. Parenting plans become part of the court order and parents are required to attend parenting education workshops. Federal regulations also authorize funding for educational and outreach activities intended to inform the public, parents and family members, and young people who are not yet parents about responsible parenting and co-parenting. Of the 106,473 services provided by AV grants in FY 2018, parent education was the most frequently provided service. It accounted for 38% of all AV services. Voluntary mediation has also contributed to increased parenting time, assisting non-custodial parents in spending more time with their children while encouraging the payment of their child support obligation. Mediation was the second most frequently provided service in FY 2018 AV grants, accounting for 23% of all AV activities. In addition to these programs, some state and local child support agencies informally assist with parenting time orders, often through programs with specific eligibility criteria. Some state agencies, such as the North Dakota Department of Human Services, provide parents with online information regarding parenting time. Other states, such as Washington, provide referrals to legal service providers or provide information about legal assistance available. In FFY 2012, AUX also exercised its grant-making authority to establish parenting time opportunities for children in the Child Support Program TOC. All of the TOC grantees must have an AUX-approved domestic violence protocol to prepare for and address family violence. Domestic violence safeguards. Domestic violence is a pattern of assaultive and coercive behaviors that operate at a variety of levels: physical, psychological, emotional, financial, and/or sexual, and that perpetrators use against their intimate partner. Child support attorneys need to be sensitive to domestic violence issues when interviewing parents because establishment or enforcement of a child support order may trigger a violent response even where the past abuse was not physical. Lack of economic stability is a primary reason victims remain or return to an abusive situation. In one study, 50% of battered women remained in an abusive relationship because they did not believe they could support themselves or their children. 90% of women with a current former abusive partner will pursue child support if they can do so safely. Because child support attorneys may also play a role in developing or facilitating a parenting time agreement, they need to understand the spectrum of parenting plans with safety components. There is no consensus on the type of parenting plan that is appropriate for families with a history of domestic violence. For some, a detailed plan may be safe. For other victims, it may be unsafe. Standard visitation plans may provide useful examples for families. Other families may benefit from the development of more individualized plans tailored to family needs or child development. In addition to supervised visitation, graduated approaches to visitation in cases of domestic violence may be appropriate for some families. Sometimes it may not be appropriate for the perpetrator of violence to spend any time with the child. Such a decision will be governed by state law and the case facts. If the child support attorney is involved with parenting time issues, it is important for the attorney to receive training on domestic violence from subject matter experts. Collaboration with an existing court program, third-party facilitator or mediator, or domestic violence program is also important. An excellent example of collaborations is the partnership of the Texas Child Support Division within the Office of the Attorney General of Texas with the Texas Council on Family Violence in developing Get Smart, Get Safe, Get Support, which is an online website to assist domestic violence victims in accessing child support services. Other state child support agencies that have recently established collaborations with their state domestic violence coalition include Arizona and Vermont. Supervised visitation and safe exchange services. In developing a parenting time plan involving children and adult victims of domestic violence, child support attorneys should consider supervised visitation and exchange services. Domestic violence advocates have long called for the use of supervised visitation and exchange services to reduce the risks to children and adult victims while providing the opportunity to have parent-child contact monitored by an appropriate third party. Congress acknowledged this need for available and appropriate supervised visitation and exchange by establishing the Safe Havens, Supervised Visitation and Safe Exchange Grant Program, Supervised Visitation Program as part of the Violence Against Women Act of 2000. Designed to increase supervised visitation and exchange services for victims of domestic violence, this program places the highest priority on the safety of both children and adult victims. Over a 3-year period beginning in 2003, the Supervised Visitation Program National Steering Committee developed principles, standards, and practices to guide the development and administration of supervised visitation program centers. These guiding principles are: Principle I, equal regard for the safety of children and adult victims. Visitation centers play a critical role in the safety of children and adult victims. Therefore, it is important that visitation centers understand that their safety needs are often linked. Principle II, valuing multiculturalism and diversity. Visitation centers should be responsive to the background, circumstances, and cultures of their community. Failure to understand the social and cultural context of parents using the centers can lead to decisions that increase the risk of harm to children and adult victims, reducing the usefulness of services. Principle III, incorporating an understanding of domestic violence into center services. Visitation centers should demonstrate a comprehensive understanding of domestic violence, and the center staff need to be aware of the ways batterers may attempt to use the services to threaten and control their victims. Principle IV, respectful and fair interaction. Visitation centers should treat every individual with respect and fairness while recognizing the abuse that has occurred within the family. Recognizing each individual's right to personal dignity is a cornerstone to effective visitation and exchange services. Principle V, community collaboration. Visitation centers should seek a community collaborative that strives to ensure responses to each family member's needs, stop the abuse of children and adult victims, and eliminate the social conditions that cause intimate partner violence. Principle VI, advocacy for children and adult victims. Visitation centers should ensure that children and adult victims have meaningful access to services. Because visitation centers interact with each member of the family, these centers can serve as a gateway through which needed services can be more readily accessed by children and adult victims who may not know the range of supportive services available in the community. Child support attorneys can help inform child support agencies about laws, research, and resources in the area of supervised visitation. They can also work jointly with domestic violence advocacy groups regarding training staff on domestic violence and integrating domestic violence awareness in child support agency policy and procedures, including the facilitation of parenting time plans. Past research has established that 90% of custodial parents elect to pursue child support if it can be done safely. Military services parenting challenges. In 2019, the Pentagon reported that over 1/3, 36.5% of active duty members have children. Of active duty members with children, the greatest proportion have at least one child age 5 years or younger. More than 2/5, 41% selected reserve members have children. Of selected reserve members with children, the majority have at least one child age 5 years or younger. While all parents that live apart from their children face parenting challenges, the challenges facing military parents are unique because of deployments and lengthy separations that complicate custody, access, and parenting plan issues. Assisting military parents in developing parenting plans that account for parenting time can increase the involvement of non-custodial fathers and mothers with their children, as well as increase the likelihood of financial support for their children. Family care plans. Service members are familiar with the need for parenting plans because the military requires certain members to develop a family care plan. A family care plan details care arrangements for a service member's family during the member's absence while on military duty. Service members, both active duty and reserve, who must have a family care plan include single parents with custody of children under 19 and married service members who have custody or joint custody of children with a parent who is not their current spouse. Each service branch has additional guidelines for developing a plan and resources to assist the member, such as family support centers and legal assistance offices. Although the family care plan is a useful tool for determining parenting decisions, it does not address all custody or parenting time issues. Nor does it take the place of a legal order for parenting time or custody. Regardless of whether there is a family care plan, either parent may seek a court order for custody or parenting time. The order will prevail if a conflict arises between the family care plan and the order. Often it is necessary for the child support attorney to explain to a service member the difference between a family care plan and a court order. The Service Members Civil Relief Act. The Service Members Civil Relief Act (SCRA) provides for, among other protections, the temporary suspension of civil, judicial, and administrative proceedings so that members of the armed forces and specified other individuals can focus their full attention on their military responsibilities without adverse consequences for themselves or their families. There are no provisions in the SCRA that are specific to custody proceedings. However, if a member receives notice that a proceeding related to custody or parenting time has been initiated against him or her during a period of military service or within 90 days thereafter, the member has the right under the SCRA to request that the action or proceeding be stayed for a period of at least 90 days. The tribunal must grant the initial request for a stay upon the member's production of certain required statements. The member also has the right to request that the court extend such a stay if necessary. Granting an additional stay is within the discretion of the court. If the member's request for an extension of a stay is denied, then the court must appoint an attorney to represent the member in the action or proceeding. If the member does request, and the court orders, a stay, be aware that there are no provisions within the SCRA regarding the establishment of a temporary custody order. The SCRA protections against a default order also protect the service member involved in a child custody proceeding. The Uniform Deployed Parents Custody and Visitation Act. In 2012, the Commissioners on Uniform State Laws approved a Uniform Deployed Parents Custody and Visitation Act to address the challenges unique to military families facing deployment and lengthy separations. As of September 2019, 14 states have enacted it. Other states also have statutory provisions that address custody and parenting time in relation to deployed service members. Such statutes create expedited processes by which temporary custody and visitation orders can be created or modified in order to ensure the least disruption to the parent-child relationship when one parent is an active service member. Several states have also created an opportunity for deployed parents to transfer their visitation rights to a third person for the duration of the deployment. Child support guidelines and parenting time adjustments. Many state guidelines permit or require a tribunal to consider the amount of time a child spends with each parent in calculating the child support award. Although states use different approaches to address the impact of parenting time on a child support award, most either include a formula within the guideline or authorize the tribunal to deviate from the guideline award. As of 2016, approximately 36 states and the District of Columbia have an adjustment in the Child Support Guidelines for parenting time. Among those states, the adjustments vary significantly, both in when and how they are applied. Less than 15 states authorize a deviation from the guideline amount in cases with shared parenting. The deviation is within the discretion of the tribunal. A few guidelines provide neither a formula nor a deviation. Most states using a formulaic adjustment provide that the obligated parent's time with the child must meet a certain threshold for there to be an adjustment of the support award. About a third of those states set the threshold at 21% to 30%. In Arizona, the percentage adjustment starts when the obligated parent has the child for 4 overnights per year. The most typical application of the adjustment is through a cross-credit. That is, the support obligation for each parent is calculated, factoring in the amount of time the child spends with each parent. The obligations are then offset against each other, with the parent owing the higher amount becoming the obligated parent. Most state guidelines that use the cross-credit approach inflate the basic child support obligation by 50% to account for duplicated expenses that the parents have related to the children. The periodic review of support guidelines rarely results in revision of these parenting time adjustments. However, states are invoking new terminology within their support guidelines, statutes, or court rules to address custody and visitation arrangements. For example, some have replaced the long-used term visitation with parenting time Arizona and Indiana, joint physical custody California, or shared responsibility New Mexico. Others are employing different terms to define the parent with whom the child resides, such as residential parent Ohio. Florida decided that even the terms residential and non-residential parent have negative connotations. Regardless of whether the child support attorney is dealing with an arrangement termed visitation, parenting time, joint physical custody, or shared responsibility, it is critical that the attorney understand the impact such an arrangement has under the forum state's child support guidelines. Most states that use a formulaic adjustment in shared parenting cases require that there be a court order for shared residential custody visitation, a parenting plan, or an agreement between the parties. Usually, the parenting plan or agreement must be filed with the court or introduced into evidence. Because they have not been involved in a divorce proceeding, unmarried parents are less likely to have a custody or visitation order qualifying them for the shared parenting time adjustment. They also may have less access to resources for development of a parenting plan or agreement. For example, these issues are usually not addressed in a Title IV child support proceeding. A few states, such as Arizona, only require proof that parenting time is or is expected to be exercised by the non-custodial parent. Drafting an appropriate parenting time plan. Increasingly, states are developing initiatives or enacting legislation that include the establishment of a parenting time plan when the initial child support order is established. It is therefore important for child support attorneys to be familiar with the issues that are typically addressed in a parenting time plan, including any minimum requirements. A child support attorney who is assisting parents with an agreement also needs to ensure that he or she is dealing with the legal parents, that the agreement does not conflict with any existing custody visitation parenting time orders, and that the agreement complies with requirements to make it legally binding. State law considerations. State law may dictate the key elements of a parenting plan. For example, some states may require that the parenting plan, at a minimum, describe in adequate detail the time that the minor child will spend with each parent. Some states may have additional requirements. For example, Florida law provides that in order for the parenting plan to be approved by the court, it must also, at a minimum, describe how the parents will share and be responsible for the daily tasks associated with the child's upbringing. Designate who will be responsible for any and all forms of health care, school-related matters, and other activities, and specify the methods and technologies that the parents will use to communicate with the child. Some states use a presumptive standard visitation parenting plan that applies unless circumstances warrant deviation. The standard plan, which may be detailed in a statute or court rule, often spells out how the child's time will be divided with each parent during regular, vacation, and holiday periods. Parents are asked to disclose any safety concerns which may trigger modification to the standard plan. For example, parents in Texas absent family violence or child abuse, harm, or neglect are entitled at a minimum to a possession schedule with their children called the Standard Possession Schedule. The Texas Standard Possession Schedule allows the non-primary parent to have possession of the child at a minimum on the first, third, and fifth weekends of the month beginning at 6 p.m. on Fridays and ending at 6 p.m. on Sundays. The non-primary parent also has possession of the child on Thursdays during the school year from 6 p.m. to 8 p.m. and for 30 days in the summer. Additionally, parents alternate having possession of the child during spring break, Thanksgiving, Christmas, and New Year holidays. Even where there is a standard parenting plan, the state law or court rule usually provides that the parties may agree to deviate from the schedule. Parenting plan forms. Some states provide online forms that parents can use. For example, Washington courts have created an online form that an acknowledged father or mother may use to bring an action to establish a residential schedule parenting plan. The form can be completed 4 years or more after the acknowledgement of paternity they signed was filed with the Washington State Registrar of Vital Statistics. There are also similar forms that separated or divorcing parents may use. The website for Oregon courts includes an online parenting plan guide and sample forms that help parents complete parenting plans that comply with Oregon law. It was developed by the State Family Law Advisory Committee's Parenting Plan Outreach Workgroup. If a parent has safety concerns, there is a safety-focused parenting plan guide and 3 different sample parenting plans. One option that provides for supervised visitation, one that provides for unsupervised no overnights, and one that provides for overnights. See Exhibit 15-2 for a sample parenting plan that provides for supervised visitation. It is important to note that while parenting plan forms may be helpful in finding ways to structure a parenting plan, there is no prescribed right way to design or use a sample plan. Attorneys should be attentive to the limitations of sample plans, literacy issues, and whether a particular plan is mandated by the court or state law. Plain language in parenting plans. Several states are looking at ways to make their family law forms more understandable by redrafting the forms in plain language and more accessible formats. Less confusion, greater clarity, better understanding, and achievement of personal and legal goals are just some of the benefits plain language forms offer. The benefits of plain language forms extend to attorneys and the courts as well. If the court does not require a particular parenting plan form, the child support attorney should ensure that the parenting plan is drafted in plain language. The attorney can use the following plain language techniques. Use smaller words and sentences. Avoid foreign words, jargon, and specialized terms. Below are some examples of how to replace complex words with short, more familiar words. Replace with advocate, attorney, lawyer. Conform, follow. Judgment, decision. Part plaintiff, defendant, you, the other person, the other side. Timely, on time. Whereas, but. Convert levels of sentence hierarchy into bullet lists or checkboxes. In Washington state, the new family law forms include new checkbox lists to replace blank lines. This technique helps to improve readability for the parents and for the judge. Eliminate extra words and unnecessary details. Use an active voice. Prefer verbs over nouns. Noun, verb. Usage, use. Completion, complete. Payment, pay. Decision, decide. Considerations when developing a parenting plan. If allowed under state law, many courts recognize that, if at all possible, parents should create their own schedule for parenting their children. If parents want to create a specific schedule, they should ensure that the parenting plan complies with any minimum statutory or court rule requirements. They also need to decide how detailed they want the plan to be. The following elements are typically addressed in a court-ordered parenting plan and may guide parents in drafting plan provisions. Weekend placement of the children, e.g., first, third, and fifth weekends of each month. Time with the child during the week, e.g. every Wednesday afternoon. Holidays, including July 4th, Thanksgiving, and religious holidays. Mother's Day and Father's Day. Birthdays, including each parent's and the children's. A number of weeks during the summer. Spring and fall break from school. Notification of children's illness or accident. Telephone access to the children. Access to information regarding the children's medical, dental, and hospital records. If the parties do not wish to have specific placement times addressed in their parenting plan, an alternative is a parenting plan that simply provides for placement at reasonable times and circumstances with reasonable notice. The parties need to ensure that such a plan meets any state requirements if they want a court to enforce it. Conclusion. Research shows that parents who spend time with their children are more likely to pay support. Such research has resulted in congressional funding of access and visitation programs, as well as AUX grants to states that want to develop access and parenting time initiatives in conjunction with the delivery of child support services. Increasingly, states are also passing state legislation requiring the development of parenting time orders and recognizing the special issues related to custody and visitation orders when one parent is an active service member. In the future, child support attorneys may be involved in addressing such issues in court and presenting either an agreement between the parents or facts for the court to consider in entering an appropriate parenting time order.